case briefs, and so much more. LSData's got what you're looking for.
In the 1984 case of Lavonia Manufacturing Company v. Emery Corp., the United States Bankruptcy Court for the Eastern District of Pennsylvania ruled that a seller who sells goods on credit has the right to reclaim the goods they sold, even if a creditor has a security interest, as long as the creditor's interest was granted after the delivery of goods and prior to the demand for reclamation. This case arose when Lavonia Manufacturing Company delivered $10,490.24 worth of yarn to their debtor on credit, despite being owed more by several creditors who held security agreements. When the debtor filed for bankruptcy 2 days later, Lavonia demanded the return of the yarn, leading to a legal dispute about their right to reclaim the goods under Section 702 of the Uniform Commercial Code. The court ruled in favor of Lavonia, finding that a seller can reclaim goods sold on credit even if a creditor has a security interest, provided the creditor has not given value to the debtor and received a security interest after the goods delivery and prior to the demand for reclamation. The court further held that a secured creditor is only considered a purchaser if they give value to the debtor and receive a security interest after goods delivery and before reclamation demand. A creditor cannot terminate a seller's reclamation right if they have pre-existing debt, unless the debt is incurred and the security interest granted after the goods are delivered.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.